right, the next compromise that the founding fathers really had to hammer through was the Commerce and Slave Trade Compromise. So they get around the Three-Fifths Compromise, and they move on to this issue. The issue is they know, everybody agrees that the new government needs to have the power over commerce. The problem is, for the South, with that power over with that power over commerce, will Congress move to legislate against the slave trade? And so, that was the issue for the South. They were also afraid that with that power, that the North, which everybody believed would have a greater say in the government just because there was more population there. They were afraid that the North would use that power over commerce and their power to tax to pay for the government out of export duties. So an export duty is when somebody manufactures something here in the United States and ships it overseas to sell it. The export duty is a tax charged by the government from which it is sent from. So in this case, it's being sent out of the United States, so the United States would tax it in an export duty before it gets to the other country. In other words, if I make shovels, they say, okay, you owe us $1 for every shovel you ship overseas to sell. Well, that increases the cost of the shovel, so it's going to make me less competitive overseas. But of course, it gives the government money. And so the South was afraid that the North would use their power over taxation and commerce, not only to interfere with the slave trade, but also to pay for the new government out of export duties. And so they insisted upon a number of things in order for Congress to have this power over commerce and taxation. So if you look at Article 1, Section 9, Paragraph 1, it says, the immigration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808. So what this is saying here is Congress cannot do anything about the slave trade for 20 years. Once the Constitution goes into effect, it's going to be 20 years. Congress was also forbidden to tax exports. So they're forbidden to tax exports. So they're willing to give this new government power to tax and the power over commerce, because Congress is forbidden to tax exports, and they're also forbidden to do anything about the slave trade for 20 years. Now, notice it's the slave trade. The slave trade is not the same thing as slavery. So the slave trade, many people interpret it as the international slave trade. So in other words, and if you look at the language of this paragraph here, you can see it's definitely talking about bringing in people from outside the United States. So they couldn't do anything even if they had the votes to do it for 20 years. After 20 years, it will still require one thing for Congress to act on this. It will require the votes in Congress. And the South will be part of Congress. And so they had that issue, that safeguard as well. Sometimes when looking at the Constitution, we focus so much on these compromises that were made. And these were not the only compromises that were made, but they were the big compromises. As we go throughout the semester, you'll see that we'll get to some other compromises that were made, one of them being the Electoral College. And so there were other compromises that were made, but one of the things we sometimes forget to recall is there were lots of things that did not need to be compromised, that everybody agreed. There was consensus on it. So here are just three right here. Federalism, and federalism will be the subject of our next week's discussion. So federalism is a division of powers between a central government and regional governments. We'll get a little more specific next week. So that did not have to be compromised. That's what they both the North and the South, the large and the small states, wanted. They wanted some control at the local level, and they wanted the national government to take prerogative over some things. Also, one of the things that did not have to be compromised was separation of powers, dividing the function of government into these three branches that we talked about, the legislative, executive, and judicial. Everybody agreed. It just needed to be there. And checks and balances, this granting of overlapping powers to check the power of government. So going again back to Madison's statement that the Madisonian dilemma, How do you create a government strong enough to control the governed, but oblige it to control itself? There were a number of methods they used to do that, one of them being the separation of powers. Another, and this is a big one, is these checks and balances. For instance, you give the power to the president to be commander-in-chief of the U.S. military. How do you make sure the president doesn't become too powerful? One of the ways you can do that is to give a related power to another branch. That is why in our system, in the U.S. system, Congress has the power to declare war. This stands to check and counterbalance to the president's power of commander-in-chief. You've got the Congress, whose function is to pass law. Can they pass any law they want? Well, no, not exactly, because the president must also sign the law in order for it to go into effect. In those rare cases where he vetoes the law, which again we'll go over all this later on, the Congress does have, the legislative branch does have a chance to override that veto and still have it become law anyway. So there's checks and balances almost everywhere you look, and even this idea of checks and balances is just permeated not only at the national level but at the state and local levels. There's this idea that there should be checks and balances. Constitution and pure democracy. When the Founding Fathers were creating the Constitution, they were not trying to create a pure democracy. A pure democracy is a democracy that rules simply by majority on all issues. Now, we are a democracy. The United States is a democracy, but it is not a pure democracy. Majorities don't rule on all issues. You take a look at the Electoral College. George Bush II, Donald Trump are our two most recent, who did not win the popular vote for president, but became president nevertheless because of the Electoral College. The Electoral College, in a sense, has become a check on popular or majority rule. You've got to go through and get a majority of the electoral votes, not necessarily the popular vote. So the Founding Fathers never intended to create a pure democracy. One of the Founding Fathers said, "I would sooner submit a test of colors to a blind man than to let the people rule." All right, in addition to this idea that they did not intend to create a pure democracy, one of the ways they also did not intend to create a pure democracy is they opted for a republic. So what is a republic? That is where citizens elect representatives to act on their behalf. So we rule, but we meaning we the people, rule, but we rule indirectly through our representatives. So you and I are not going off making law, but our representatives are making law. So this was just a check on public opinion, because our views would be filtered through representatives. So again, the Constitution did not intend to create a pure democracy. There is evidence of that. In addition to those, the idea is we did have popular rule as one element of the Constitution, meaning majorities are simply are entitled to rule simply because they are a majority. If there's 51% of people in favor of something, 49% opposed, the 51% have the right to rule simply because they are a majority. That's what democracy is, majority rule. But on the most important issues, the Founding Fathers opted for two kinds of majorities: a majority of voters and a majority of states. So with the Electoral College, this is precisely what is going on. There is a majority of voters needed in most instances, and a majority of states, and that is done through the Electoral College, and you'll see this more when we get to the presidency. Also, another way that they insisted that they militated against pure democracy was, in some instances, they insisted upon supermajorities. So a majority is simply 50% plus 1. A supermajority might be 2/3 or 3/4. For instance, in order to propose an amendment, you need 2/3 of the legislature or a special convention called by the legislature. In order to approve to approve an amendment, you need 3/4 of the states minimum, or a special convention called where the states vote, and 3/4. That is far greater than democracy. So in some instances, the founding fathers insisted on supermajorities, not just a majority. And on other issues, the founding fathers opted to remove democracy from the political equation altogether. For example, if you look at the Supreme Court, or the courts in general, they protect individual rights. And how do they protect individual rights? They protect individual rights through a process of judicial review. What is the process of judicial review, or how is that defined? And that is defined as the power of the courts to overrule a law passed by the legislature if the law contradicts the Constitution. Now, the most important, I can't emphasize that enough, and as proof that I can't emphasize it enough, I'm going to have you watch two videos where I explain something, all relative to this idea of judicial review, and then we'll come back. So we're going to have to break here in a minute. But before we break, let me just say this. Marbury versus Madison in 1803 is the most, even to this date, is the most important Supreme Court case ever decided, because it established the court's power of judicial review. And we'll talk about this specifically when we get to the courts. And to show you how this works, for now, to show you how this works, I'm going to give you an example that I call YM18. It's going to be in the next two videos. It's going to be YM18-1, YM18-2. I might have it also with a subtitle on there of which constitutional video this is. So watch those next two videos, and then we'll come back and discuss that a little further.